Hi, my name is Nick Mermiges, and right now I'm going to explain what happens during a motion for temporary relief in South Carolina. Um, Motions for temporary relief are filed in family court cases, whether it's a custody case or a divorce case or a case seeking separate support and maintenance while the parties are separated. Um, and what a motion for temporary relief is basically one of the two parties is asking the court for some kind of a temporary interim ruling. So it could be a temporary decision on who has custody of the kids. It could be a temporary decision on who gets to stay in the marital home, who gets to drive what car. Temporary decision on whether one spouse has to pay alimony to the other spouse during the process of the lawsuit. A temporary ruling that one spouse can't contact the other spouse. Most of the relief that you would ask for in a final divorce, there's kind of a temporary version of it, particularly alimony, or for a non-working spouse, you could ask for the other spouse to have to pay your attorney's fees. The issue with motions for temporary relief is they only generally last about 15 minutes. The court hearing only lasts about 15 minutes. And that's not a whole lot of time to make a decision about how things are going to be situated for generally the next year going forward. So these can be pretty high stakes hearings. If we always encourage our clients to at least try to talk to the other side and see if there's areas that they can agree on, just so that they reduce any uncertainty that comes with these hearings. Now, and a lot of the times, there will be one party bringing a divorce, and then the other party gets served with papers, and that hearing is coming up in like 10 or 11 days. And so the person getting served is really going to have to scramble to put together the money to hire a lawyer, and then to be prepared for that hearing, to have the lawyer, spend the time with them to sit down and be prepared for that hearing. So in a lot of ways, these motions can be kind of surprising, and you want to be prepared for them. In general, in motions for temporary relief, the standard motion, unless somebody is asking the court to do things differently, which is pretty rare, neither side testifies. Neither the husband nor the wife have to say anything in court. Instead, what will happen is the lawyer will prepare an affidavit for that person, so a written statement that's been verified like sworn testimony. You'll have to go get it notarized at a notary public, and it'll explain, what's happened, why you are where you are now, and what kind of relief you're looking for. Whether you want use of the home or temporary support, or you want use of the car, explaining why you should be entitled to that, and what you're seeking. Like I said, it's only in a written form. So the lawyer's going to have to meet with the client beforehand and help them really prepare that affidavit. In addition to that, each party is required to submit a financial disclosure. There's South Carolina Form 430. It lays out your assets, debts, and income. Why is that? Well, that's because when a judge is deciding about issues about who's going to pay for what, which is usually, besides custody, the most common reason you go in on a motion for temporary relief, they need to know where the money's coming from so that they can make an equitable decision. You're also going to be able to present affidavits from friends, family, and fact witnesses, but you're limited to 8 total pages of affidavits. That does not include exhibits. So if in one affidavit you say, I've got bank records, showing that he's been gambling $5,000 a month, you can attach the bank records, even if it's like 50 pages of bank records. But the 8 pages is a strict limit. Apart from that, your attorney will usually prepare an affidavit asking that the other side pay your fees. Sometimes that'll work, sometimes it won't. It's really going to depend on the relative economic position of both sides, and the judge is going to make the decision based on that. So basically, both sides are going to get the opportunity to submit their written affidavits and financial disclosures, and then usually the judge will also let the lawyers make a brief 5 to 10 minute argument on each side, and the judge will usually, after having done that, make a ruling from the bench. And the judge will say, the the husband's going to be entitled to the car, the wife is going to be temporarily entitled to the house. I'm not going to award attorney's fees at this time. Any issue that's disputed, the judge will order a ruling, and then they'll order one of the attorneys to prepare a court order based on the verbal ruling. Okay? There's going to be a court reporter that records everything that's said in the hearing. There's going to be usually a bailiff there. And apart from that, normally the only folks in the courtroom are the litigants, you know, the husband and the wife, or the mother and father, the lawyers for each side, the court staff, and then you can bring family members with you. But normally it's not something that's really open to the general public. That's not how it's done in practice most places. Now, that being said, every judge is a little bit different. But the rule does specifically say, the family court rule does specifically say that you're not really allowed to give any kind of live testimony. It's going to be those affidavits and that financial disclosure. And so that's why if you find yourself served and you've got a hearing coming up on temporary relief, you definitely want to find a lawyer as quickly as possible that you're comfortable with and that you want to work with, so that the two of you can sit down and deal with sufficiently preparing affidavits, so that the judge has something to consider and they can hear your side of the story. Once the order is entered, it's a binding court order, meaning that if you violate it, if you've got to pay child support or alimony and you don't pay it, you can be held in contempt of court. So you have to follow the rules of that order. Now, if circumstances change, if it shows that one party wasn't being truthful about their income, for example, you can go back into court. But you do have to generally show a substantial change of circumstances that would justify changing that temporary order. How long does that order last? Well, the order is going to last until there's another order that's issued, or until there's a final order in the case. Okay, so it generally is going to last the length of that case. And most family court cases don't last longer than a year, because there's a requirement that you request a final hearing within a year of filing. Okay, so it's going to, whatever is in that order is going to last until there's either a modification to it, or until the case is dismissed, or until there's a final order dealing with the divorce. So I hope that gives you some sense of what happens at a hearing on a motion for temporary relief, and why it's important to act and to get an attorney to help you to prepare those written documents so that you get a fair shake. I hope this has been informative, and I wish you the best. Thank you.